Francisco Joaquin and BJ Productions Incorporated vs. Han Franklin Drilon, Gabriel Zosa, William Esposo, Felipe Medina, Jr., and Casey Francisco Gr. No. 108,946, January 28, 1999. Justice Mendoza. Facts of the case: petitioner is the holder or grantee of a copyright of Rhoda and Me, a dating game show aired from 1970 to 1977. Respondent, on the other hand, is the president and general manager of IL Productions, which produced the dating game show, It's a Date. Petitioner then wrote a letter to private respondent, Gabriel Zosa, informing him that BJPI had a copyright to Rhoda and Me and demands that IXL discontinue airing It's a Date. Respondent apologized, however it continued to air the said show. Later, petitioner filed information against respondent for alleged violation of PD number 49. Assistant prosecutor's basis of finding such violation is the written descriptions of the formats of the television shows, wherein he ruled that the major concepts of both shows are the same and that any difference appears mere variations of the major concepts. Respondents then sought a review of the said information filed by the assistant prosecutor before the Department of Justice. DOJ Secretary Franklin Drilon reversed the AP findings and directed him to move for dismissal of the case against private respondents. Petitioners assert that the format of Rhoda and Me is a product of ingenuity and skill and is thus entitled to copyright protection. It is their position that the presentation of a point-by-point comparison of the formats of the two shows clearly demonstrates the nexus between the shows and hence establishes the existence of probable cause for copyright infringement. Hence, this petition. Issues to be resolved: 1. The format or mechanics of a show is entitled to copyright. Ruling of the court: format of a show is not copyrightable. The format or mechanics of a television show is not included in the list of protected works in PD 49. Copyright, in the strict sense of the term, is purely a statutory right. It is a new or independent right granted by the statute, and not simply a pre-existing right regulated by the statute. Being a statutory grant, the rights are only such as the statute confers, and may be obtained and enjoyed only with respect to the subjects and by the persons and on terms and conditions specified in the statute. PD number 49, 2, in enumerating what are subject to copyright, refers to finished works and not to concepts. The copyright does not extend to an idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. Petitioner's copyright covers audiovisual recordings of each episode of Rhoda and Me, thus the copyright does not extend to the general concept or format of its dating game show. Mere description by words of the general format of the two dating game shows is insufficient. A television show includes more than mere words can describe because it involves a whole spectrum of visuals and effects, video and audio, such that no similarity or dissimilarity may be found by merely describing the general copyright/format of both dating game shows. Francisco Joaquin and BJ Productions Incorporated vs. Han Franklin Drilon, Gabriel Zosa, William Esposo, Felipe Medina, Jr., and Casey Francisco Gr. No. 108,946, January 28, 1999. Justice Mendoza. Facts of the case: petitioner is the holder or grantee of a copyright of Rhoda and Me, a dating